386. How does a contractor notify the government when it has a problem that could result in an equitable adjustment or a claim, and how does the government respond to this notification?
When a contractor has a problem performing the contract work, he or she usually contacts the CO or the Corps by phone to inform them that a problem has arisen. This initial contact is not a claim. The government usually responds to the contractor's phone call with a letter, asking that the problem be stated in writing. The contractor will then respond with a letter describing the problem. The contractor's letter might be more than a simple notice that there is a problem. It could request an equitable adjustment to resolve the problem informally, or it could represent a claim that could result in litigation. Usually, at this early stage, the contractor does not know how severe the problem will be, what will be required to correct it, or how much a solution will cost. Without this information, it is too early to proceed with a request for equitable adjustment or a claim. At this point, the Corps must investigate the problem and assist the CO in determining whether the contractor is due more money, time, or both, and if so, how much more. In the meantime, the contractor will investigate the problem, determine exactly what the problem is, and specify what is needed to resolve it. The contractor will probably send a written request for the CO to make an equitable adjustment to the contract to correct the problem. The government will then agree to pay added costs, adjust the delivery schedule, or provide any other considerations that it deems appropriate. Most of the time, the government will comply with the contractor's request, make the equitable adjustment, and modify the contract to effect the change. However, there are instances in which the contractor and the government cannot agree, and the contractor decides to file a formal claim demanding that the CO make a final decision. The CO has the authority to make the final decision for the government, either granting the contractor its claim or denying it. Whatever the decision, the CO must issue a formal final decision to resolve the claim. A CO's final decision denying the contractor's claim entitles the contractor to file an appeal to a Board of Contract Appeals or the Court of Federal Claims. Sometimes, determining whether a notice sent by a contractor is an actual claim can be difficult. Notice may only be a simple notification of a problem, or it could be a request for equitable adjustment that can be resolved informally. Unfortunately, there are no criteria that can be applied in every instance to reach a fail-safe decision on whether or not a notice is really a claim. If a Corps receives a letter from a contractor in which the contractor's intentions are not made clear, the Corps should initiate discussion of the problem with the contractor to gather information about the contractor's perception of the problem. Informally attempt to determine what sort of resolution the contractor is seeking. Talk to someone who may have dealt previously with the problem. Join the CO in consulting with legal counsel, if necessary. If considered necessary based on the particular circumstances and with the CO's concurrence, write a letter to the contractor asking if a claim is being submitted.